Hello viewers, today we will discuss the topic Cyber Appellate Tribunal. The Information Technology Act 2000, which came into force on 17th October 2000, was enacted to provide legal recognition for transactions carried out by means of electronic data, interchange and other means of electronic communication, commonly referred to as electronic commerce, which involves the use of alternativeness to paper-based methods of communication and storage of information to facilitate electronic filing of documents with the government agencies and to amend the Indian Penal Code, the Indian Evidence Act 1872, the Bankers Book of Evidence Act 1891 and the Reserve Bank of India Act 1934, and also for the matters connected therewith or incidental thereto. The first and the only cyber appellate tribunal in the country has been established by the central government in accordance with the provisions contained under section 48 subclause 1 of Information Technology Act 2000. The tribunal, initially known as the Cyber Regulations Appellate Tribunal, after amendment of the IT Act in year 2008, which came into effect on 27th October 2009, is known as the Cyber Appellate Tribunal. The tribunal started functioning from October 2006 in portion of the Department of Information Technology building at CGO Complex, Lodhi Road, New Delhi. The Act provided for the tribunal to be headed by the presiding officer, who is or is qualified to be a judge of the High Court. Honorable Mr. Justice R.C. Jain, a retired judge of Delhi High Court, was the first presiding officer of the Cyber Appellate Tribunal, who joined as a presiding officer on 4th October 2006. The tenure of Mr. Justice R.C. Jain as presiding officer of Cyber Appellate Tribunal expired on 7th December 2007. Now, we will briefly discuss roles and powers of the Cyber Appellate Tribunal. Establishment of Cyber Appellate Tribunal is defined in section 48. The central government shall by notification establish one or more appellate tribunal to be known as Cyber Regulation Appellate Tribunal. The central government shall also specify the notification referred to in subsection 1, the matters and places in relation to which the Cyber Appellate Tribunal may exercise jurisdiction, though the aforesaid subsection provides for appointment of one or more appellate tribunals by the central government, but the language of the Rule 13 of Cyber Regulation Tribunal Rules 2000 make it clear that there shall be only one tribunal and it should ordinarily hold its sitting at New Delhi. The aforesaid rule has further provided a lots of flexibility to Cyber Appellate Tribunal as far as its sittings are concerned. That is, if at any time the chairperson of the tribunal is satisfied that circumstances exist which rendered it necessary to have sittings of the tribunal at any place other than New Delhi, the chairperson may direct to hold the sittings at any such appropriate place. It is for the chairperson to exercise this rule of sittings in a most appropriate and judicious manner. The tribunal shall notify to the parties the date and the place of hearing of the application. It is for the central government to specify by order the matters and places in relation to which Cyber Appellate Tribunal may exercise jurisdiction. It was held by the Supreme Court in Union of India versus Paras Laminates Limited. There are no doubt that the tribunal functions as a court within the limit of its jurisdiction. It has all the powers conferred expressly by the statute Furthermore, being a judicial body, it has all the powers conferred expressly by the statute. Furthermore, being a judicial body, it has all the powers expressly and impliedly granted. Then we will discuss the composition of Cyber Appellate Tribunal, which is defined in section 49 of the IT Act. Cyber Appellate Tribunal shall consist of one person only, hereinafter referred to as Presiding Officer of Cyber Appellate Tribunal, to be appointed by notification by the central government. Qualifications for the appointment as Presiding Officer of the Cyber Appellate Tribunal is defined in section 50. A person shall not be qualified for the appointment as the Presiding Officer of a Cyber Appellate Tribunal unless he or has been or is qualified to be a judge of the High Court or has been a member of the Indian Legal Service and is holding or has held a post in grade 1 of that service for at least 3 years. Then we will discuss his term of the office, which is defined in section 51. The Presiding Officer of Cyber Appellate Tribunal shall hold office for a term of 5 years from the date on which he enters upon his office or until he attains the age of 65 years, whichever is earlier. Salary, allowances and other terms and conditions of services of Presiding Officer is defined in section 52. The salary and allowances payable to and other terms and conditions of services including pension, gratuity, other retirement benefits of the Presiding Officer of the Cyber Appellate Tribunal shall be such as may be prescribed, provided that neither the salary nor the allowances or other terms and conditions of the services of the Presiding Officer shall be varied to his disadvantage after appointment. Then we will discuss power of superintendence, direction, etc. Section 52A defines the chairperson of Cyber Appellate Tribunal shall have powers of general superintendence and directions in the conduct of the affairs of that tribunal, exercise and discharge such powers and function of the tribunal as may be prescribed. The chairperson, being the head of the Cyber Appellate Tribunal, has both executive and administrative powers of the general superintendence and direction in the conduct of the affair of the tribunal, which may include presiding over the meeting of the tribunal, exercise and discharge such powers and functions of the tribunals as may be prescribed. Distribution of business among benches is defined in section 52 subclause B. Where benches are constituted, the chairperson of Cyber Appellate Tribunal may by order distribute the business of that tribunal among the benches and also the matters to be dealt with by each bench. The aforesaid section refers to an administrative function. There is the distribution of business among benches. It shall be the prerogative of the chairperson to distribute the business among the benches and also the matters to be dealt with by each bench. This provision may become useful in the coming year with the increase in litigation and more appeals coming before the Cyber Appellate Tribunal. Then powers of the chairpersons to transfer cases defined in section 52C. On the application of any of the parties and after notice to the parties and after hearing such of them as he deemed proper to be heard or suo motu without such notice, the chairperson of Cyber Appellate Tribunal may transfer any case pending before one bench for disposal to any other bench. The aforesaid section refers to a judicial function. There is power of the chairperson to transfer cases after either following the laid down procedure or suo motu may transfer any case pending before one bench for disposal to any other bench. Decision by majority, which is defined in section 52D. If the members of a bench consisting of two members differ in opinion on any point, they shall state the point or points on which they differ and make a reference to the chairperson of the Cyber Appellate Tribunal, who shall hear the point or points himself, and such point or points shall be decided according to the opinion of the majority of the members who have heard the case, including those who first heard it. The first section advocates the rule decision by majority. This section also refers to constitution of large bench. If the members of the bench consisting of two members differ in opinion on any point, it shall be prerogative of the chairperson to constitute such large bench. The larger bench shall be headed by the chairperson and consists of the members including those who first heard it. Then we will discuss section 53, which talk about filling up of vacancies. If for reason other than temporary absence, any vacancy occurs in the office of the presiding officer of a cyber appellate tribunal, then the central government shall appoint another person in accordance with the provision of this act to fill the vacancy, and the proceedings may be continued before the cyber appellate tribunal from the stage at which the vacancy is filled. Then section 54 talk about resignation and removal. The presiding officer of cyber appellate tribunal may, by notice in writing under his hand addressed to the central government, resign his office, provided that the said presiding officer shall, unless he is permitted by the central government to relinquish his office sooner, continue to hold office until the expiry of 3 months from the date of receipt of such notice, or until a person duly appointed as his successor enter upon his office, or until the expiry of his term of office, whichever is earliest. The presiding officer of cyber appellate tribunal shall not be removed from his office except by an order by the central government on the ground of proved misbehavior or incapacity after inquiry made by a judge of the Supreme Court, in which the presiding officer concerned has been informed of the charges against him and given a reasonable opportunity of being heard in respect of these charges. The central government may by rules regulate the procedure for the investigation of misbehavior or incapacity of the aforesaid presiding officer. Order constituting appellate tribunal to be final and not to invalidate its proceeding is defined in section 55. No order of the central government appointing any person as presiding officer of a cyber appellate tribunal shall be called in question in any manner, and no act of proceeding before cyber appellate tribunal shall be called in question in any manner on the ground merely of any defect in the constitution of cyber appellate tribunal. Then we will discuss section 56, which defines staff of the cyber appellate tribunal. The central government shall provide the cyber appellate tribunal with such officers and employees as that government may think fit. The officers and employees of cyber appellate tribunal shall discharge their function under general superintendence of presiding officers. The salary, allowances and other condition of service of the officers and employees of the cyber appellate tribunal shall be such as may be prescribed by the central government. Then we will discuss section 57, which define appeal to the cyber appellate tribunal. Save as provided in subsection 2, any person aggrieved by an order made by the controller or an adjudicating officer under this act may prefer an appeal to the Cyber Appellate Tribunal having jurisdiction in the matter. Subclause 2 defines no appeal shall lie to the Cyber Appellate Tribunal from an order made by an adjudicating officer with the consent of the parties. Every appeal under subsection 1 shall be filed within a period of 25 days from the date on which a copy of the order made by the controller or the adjudicating officer is received by the person aggrieved, and it shall be in such form and be accompanied by such fee as may be prescribed, provided that the Cyber Appellate Tribunal may entertain an appeal after expiry of the said period of 25 days if it is satisfied that there was sufficient cause not filing it within that period. Fourth clause said, on receipt of an appeal under subsection 1, the Cyber Appellate Tribunal may, after giving the parties to the appeal an opportunity of being heard, pass such orders thereon as it thinks fit, confirming, modifying or setting aside the order appealed against. Clause 5 explains the Cyber Appellate Tribunal shall send a copy of every order made by it to the parties to the appeal and to the concerned controller or adjudicating officer. The appeal filed before the Cyber Appellate Tribunal under subsection 1 shall be dealt with by it as expeditiously as possible, and endeavour shall be made by it to dispose of the appeal finally within 6 months from the date of receipt of the appeal. Then we will discuss the procedures and powers of Cyber Appellate Tribunal, which is defined in section 58. The Cyber Appellate Tribunal shall not be bound by the procedure laid down by the Code of Civil Procedure 1908, but shall be guided by the principles of natural justice and subject to other provisions of this Act and of any rules. The Cyber Appellate Tribunal shall have powers to regulate its own procedure, including the place at which it shall have its sittings. The Cyber Appellate Tribunal shall have, for the purpose of discharging its function under this Act, the same powers as are vested in the Civil Code under the Code of Civil Procedure 1908. While trying a suit in respect of the following matters, namely, summoning and enforcing the attendance of any person and examining him on oath. Then, requiring the discovery and production of document or other electronic records, receiving evidence on affidavits, issuing commissions for the examination of witness or documents, then reviewing its decision, dismissing an application for default or deciding it ex parte, any other matter which may be prescribed, any proceedings before the Cyber Appellate Tribunal shall be deemed to be judicial proceeding within the meaning of section 193 and 228 and for the purpose of section 196 of the Indian Penal Code. And the Cyber Appellate Tribunal shall be deemed to be a civil court for the purpose of section 195 and chapter 26 of the Code of Criminal Procedure 1973. Then we will discuss right to legal representation, which is defined in section 59. The appellant may either appear in person or authorize one or more legal practitioner or any of its officer to present his or its case before the Cyber Appellate Tribunal. Then we will discuss section 60, which defines limitations of the period. The provision of the Limitation Act 1963 shall, as far as may be applied to an appeal made to the Cyber Appellate Tribunal, civil court not to have jurisdiction, is defined in section 61. No court shall have a jurisdiction to entertain any suit or proceeding in respect of any matter which an adjudicating officer appointed under this Act or the Cyber Appellate Tribunal constituted under this Act is empowered by or under this Act to determine, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by under this Act. Then appeal to High Court was explained in section 62. Any person aggrieved by any decision or order of Cyber Appellate Tribunal may file an appeal to the High Court within 60 days from the date of communication of the decision or order of Cyber Appellate Tribunal to him on any question of fact or law arising out of such order, provided that the High Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period, allowed it to be filed within a further period not exceeding 60 days. Then section 63 explain compounding of contravention. Any contravention under this chapter may either before or after the institution of adjudicating proceedings be compounded by the controller or such other officer as may be specially authorized by him in this behalf, or by adjudicating officer as the case may be, subject to such condition as the controller or such other officer or the adjudicating officer may specify, provided that such sum shall not in any case exceed the maximum amount of penalty which may be imposed under this Act for the contravention so compounded. Nothing in subsection 1 shall apply to a person who commits the same or similar contravention within the period of 3 years from the date on which the first contravention committed by him was compounded. Explanation for the purpose of this subsection: any second or subsequent contravention committed after expiry of the period of 3 years from the date on which the contravention was previously compounded shall be deemed to be the first contravention. Where any contravention has been compounded under subsection 1, no proceeding or further proceeding as the case may be shall be taken against the person guilty of such contravention in respect of contravention so compounded. Then we will discuss section 64, which explain recovery of penalty. A penalty imposed under this Act, if it is not paid, shall be recovered as an arrear of land revenue, and the license or the digital signature certificate, as the case may be, shall suspended till the penalty paid. In concluding remarks, I must say the first Cyber Appellate Tribunal has been established by the central government under the Information Technology Act 2000. The motive of the Cyber Appellate Tribunal is to stop the cyber crime and frauds over a period of time. These tribunals discharge their powers as same of the Supreme Court under the Code of Civil Procedure 1908. The duties of the Cyber Appellate Tribunal are discharged by one person who is known as a presiding officer. He acts and discharges duties as Supreme Court judge. Thank you viewers for watching this program.